Hello, everybody. Thank you for tuning in to my channel today. As you know, my name is Tory. I'm a licensed realtor with EXP Realty. And as you can see, we have a very special guest with us today. So this is a lawyer, Alex, and she's going to be giving us a lot of tips on things to look out for when you guys are handling your different files with your different clients. How are you doing, Alex?
Good, how are you?
Good, thank you. Did you want to tell us a little bit about you and what firm you're with?
Yes, first of all, thank you so much for having me today. I am working out of Hamilton, downtown Hamilton, Ontario. I'm with Bartolini, Berlingieri, Barrafato, Fortino law firm. We are a full service firm in Hamilton, and I specialize mainly in civil litigation and family law. So I do have a lot of real estate. I do interact a lot with real estate on my files, given that when couples separate, they have a matrimonial home that likely needs to be sold. So that's where I'm here today to give you some tips and not advice, but tips today on all those issues.
So I have a list of questions that I personally have when dealing with my own clients and some that other people have shared with me as well.
Okay.
So we'll just have basically a question and answer session now.
Beautiful.
And for all of you viewers out there, if you guys have any questions, feel free to comment below, or I will put Alex's contact information on the screen and you can reach out to her directly as well.
Thank you.
Okay, so the first question, and these ones are mainly related to common law relationships.
Mm-hmm.
So is common law the same as a marriage in the eyes of the law?
Perfect. Just to preface this, obviously, everything I'm saying today is not a substitute for legal advice. So if anyone is going through anything today, please make sure to consult a lawyer. That's my best advice for you, and it's worth every minute because there are a lot of things that can happen in a family law matter that a lot of people don't know about. In terms of that question, the short answer to that is no. Married spouses have a lot more rights in terms of property. So off the bat, common law spouses don't have regular property rights. That's just because when you get married, obviously everything becomes joint. So it's a very different, there's very different implications if you're married and if you're common law. That being said, common law spouses do have a right to make resulting trust or constructive trust claims against any property that either they're living with their spouse and at the time of separation.
Great. And can you describe what is a separation agreement?
A separation agreement is basically a regular contract. It's an out-of-court process where two parties, married or common law, doesn't matter, you can basically resolve all of your issues arising from your separation by way of an agreement. So I like to do this for my clients just because it's a lot more cost-effective than going to court because there's so many fees and more time involved when you have to actually start a court application. An agreement basically just sets out every single issue that you guys might, like the married or common law couple might have. So that ranges anywhere from property to the matrimonial home to child custody and access. I basically write those on a daily basis. I just finished signing one up right now. But it resolves all of the issues. And if you're married, separation agreements are usually always required if you want to get a divorce. So usually when you file your divorce affidavit, you have to usually attach a separation agreement so that you let the court know that you have outstanding issues and you've dealt with it. Especially if there's children, the court's going to want to know if the parties have taken care of the kids and support and what have you. So those are usually always necessary when you want to file for a divorce. But an agreement doesn't necessarily have to be filed with the court. It can just be signed and it's a valid contract and it stands until someone challenges it, which is always fun.
So in relating to real estate, if there is a common law spouses who are looking to separate and looking to sell their home, does that separation agreement need to be signed before the home goes on the market or before the home closes?
It's usually before the home closes, and that's not like a blanket answer like all the way through, but it's usually before the home closes. And the reason for that is simply because if you're getting a mortgage for the next property, or you have to split the proceeds, the real estate lawyer who's on that transaction will likely, like more times than not, will likely require a separation agreement that is fully executed by both parties. And it says basically that this is how you're going to divide the proceeds, and this is where the proceeds are coming from. This is how you're going to pay off the mortgage, etc. So usually it's prior to closing. You'll need that agreement fully executed.
Just regarding the amount of years that they're together. So common law relationships, is there a certain amount of years that they have to be either living together or in that relationship to constitute as a proper union?
Yes, yeah. So it's either 3 years in living together in Ontario. The law says 3 years in Ontario, and or you have a child together. So you can, if you have a child together, you've been together only for 2 years, you're still considered common law under Ontario family law, or it's 3 years living together without a child.
And so regarding spousal buyout, can you explain that process and maybe a little bit how it's done, if that's an option for someone if they don't necessarily want to sell the home and both parties leave?
Yes. So usually a buyout entails when both parties are on title. Okay, so whether you own it 80-20, you own it 80%, 20%, or you own it 50-50. If one person wants to stay in the home, they will have to buy out the other party's interests, which just means that you also have to complete a transfer, meaning you're transferring the one person who wants to be bought out. They're transferring their interest completely to the other party, so the other party will own it eventually 100%. So that will have to happen, and in exchange of that, you pay them a percentage of their interest. The interest is the portion, your buyout is basically calculated by fair market value, or a value that both parties agree to, less any mortgage that you have. So it's basically half of the equity in the home. That's how the buyout is usually calculated.
And if one common law partner, paid a larger down payment when they first moved into the home than the other partner, when you're looking to sell, is it split on that same percentage, or is it just 50-50 regardless?
That's a great question, and I get that question all the time. It's usually the person who put the down payment down, they get credit for that. So say they put down 100K, that will usually, if the both parties agree, you get that 100K back. Everything above and beyond that is split 50-50, or how the couple owns title. But more times than not, it's usually 50-50.
And can one partner sell the house without the permission of the other partner?
No. There's a spousal release that you have to sign, and usually you'll know this better than me, Tory, but on the forms, there's always a spot for the other spouse and the other title holder to sign. So you definitely need their cooperation. And when there's no cooperation, that's usually where I come in, and I'm bringing motions in court to have to get orders that either compel people to comply with the sale, or I just dispense with their participation in general. That's what I would likely have to do, because there are times when people it's so acrimonious that they just have one person just said, listen, like, I want to just handle the sale on my own. So I usually bring a motion for that when it gets to that point. But other than that, yes, when two people are cooperative and amicable, you do need to sign off on that sale.
Absolutely. And that's one, even if the other partner is not on title, you would still require their consent on the agreement of purchase sale before everything become legal and binding, because if you are missing that additional signature and that other party does make an issue of it before closing, it can bring up some really big issues. So always play it safe and sorry, and get all signatures ahead of time.
Yeah, because there's a spousal interest there, so that's absolutely right.
Okay, so now in relation to the separation end of things, so once both parties have agreed that they want to be separated, when a couple is married, they have to be separated for at least 1 year before applying for divorce. What is the process on the common law side? Once the assets are divided, or once the separation agreement is in place, do they just part their separate ways, or is there any kind of time limit?
There's no time. Yeah, that's a great question. You're right. So it's 1 year before you can apply for a divorce for married couples. For common law spouses, it's usually, I just had a conversation with someone this morning about it. It's usually just the date that both parties agree that they are separated. So there's no, once the agreement is signed, I mean, that means your issues are all resolved on a final basis, and it's contractually binding, obviously, because both parties will sign it. Plus, you'll have a witness that witnesses both parties' signatures. Other than that, the separation date for common law spouses is just the date that they both agree, like there's been a complete breakdown in the relationship, and they're no longer together. So there's no real like formal document for a common law relationship in terms of separation dates.
And then on the note of the 1 year time frame for married couples, typically it is the 1 year. Can you explain any scenarios that would allow it to be less than a year?
There's only that's not very common, just because you'd have to bring a motion at court and you'd have to get leave from a judge stating that you do not have to wait the full year. Usually, I mean, extenuating circumstances would basically have to exist before a lawyer brings that, asks the court for that permission. The most common one I've seen is probably when there's when one partner wants to get remarried. It cannot be married to two people at the same time in Ontario, so you will need that divorce expedited as soon as possible. I've seen that happen, and that would just be like brought by way of a motion just to get an order or consent. So if the other party agrees to that, to wait less than the 1 year waiting period, they can do that, or likely you need a motion in court. But basically that's the gist of that.
Just to piggyback off of that as well, if there is something excruciating circumstances, like you said, in the sense of domestic violence, is that a time frame that still needs to apply, or is that case by case scenario?
I wouldn't say that would expedite the divorce. It's definitely a factor in terms of your living situation. I mean, that's a very big factor. So I would obviously always advise my clients, if there's domestic violence, they should have a safety plan in place for them and the kids, if there's kids. In terms of a divorce, though, the divorce really is just a piece of paper that nulls your marriage in Ontario. So until that divorce order comes out, you can still be separated. So you're under the CRA and everything, you can still file as being separated. But the divorce really is just your marriage is no longer valid, basically. So in terms of domestic violence, I mean, I would say make sure you get out of the home, have a safety plan in place, have alternate accommodations ready. But you can be separated until then. There are couples out there that aren't that never get divorced. If they never want to remarry, they don't have to, right? But that's yeah, I would say in a situation like that, definitely have a safety plan and have alternate accommodations as soon as you can.
Okay, and can you describe what is considered a matrimonial home?
The matrimonial home is the home that a married couple lives in at the time of their marriage. Like the instant that you're married, it becomes a matrimonial home. And then after that, if you move or what have you, and you separate, it's the home that you're living in at the time of separation. So it's just the home that the married couple occupies throughout their relationship.
And is that still considered a matrimonial home if it is a common law couple?
So it's not considered a matrimonial home because they're not married. A common law couples, they do not necessarily have as much or the vast majority of property rights like married couples do. But the home that they're living in, it depends how they hold it. Like if they hold title to it, then obviously they own it under the Titles Act in Ontario, but it's not considered a matrimonial home. So there's different rights that attach to both types of couples.
And last question, can you have more than one matrimonial home?
No. That's a great question. No, you cannot. You can have secondary homes, obviously investment properties and etc., depending how you hold title to it. But no, there's only one matrimonial home.
Okay, well, thank you so much for answering all of those questions. I hope you all found that helpful information as well. And again, if you guys have any further questions or need clarification, feel free to comment below, or you can reach out to Alex directly. Thank you so much, Alex.
Thank you so much again for having me today.